Well, welcome everyone. My name is Ken Vercammen, and I'm an attorney in Edison. I'm here to discuss what's new in wills, probate, estates. And so if you have some questions, you can jump up. Believe it or not, New Jersey has reduced some of their taxes. A few years ago, every dollar over $675,000 was taxed. New Jersey did away with the estate tax. They also made the inheritance tax, so there's no tax if it's going to spouse, children, or grandchildren. However, it does apply to some of the people in the room, the federal estate tax. That's for you people here who may have more than $13,900,000. Everyone else is cool. So, a lot of times people say, hey Kenny, why do I need to have a will? Doesn't everything go to my wife or my kids? It goes, well, that, yes and no, sometimes it does, sometimes it doesn't, but that's not really doing planning. The whole idea is making things easier for your family so there's less stress and aggravation down the road. If you had a house and there was a pipe leaking in the basement, would you say, you know what, I'm going to save you money, I'm not hiring a plumber, I'll just let my kids deal with it in a couple of years when I pass? No, you get it fixed. So, if someone doesn't have a will, or the will is not admitted to probate because they tried to use a free, cheap thing online and didn't do it right, then the process to distribute assets becomes much, much more complicated. So, let's say there's 3 kids, and they all agree, okay, they got to agree upon who's going to be the administrator. The ones who aren't the administrator have to sign what's called a renunciation. And the renunciation says that, hey, I'll let someone else be the administrator. I'm saying they got to be signed from a notary and a fee paid for that renunciation to be filed. Well, that's in the states where everyone agrees. Sometimes you get the troublemaker kid that goes, no, I want to be the executive. Well, how can you be the executive? You live in Oregon and you haven't been around for 15 years. Well, I want to do it. So that means that the person who wants to be the administrator has to file a complaint, want to show cause, pay a couple grand, and then have the judge call who's there. And sometimes what the judge does, he goes, okay, you guys are fighting, I'm going to appoint someone on the outside, and then they're going to take a commission and run up the fees. The other thing is if there's no will, the will is not admitted to probate, then the administrator has to take out a bond. But the most important thing you kind of got to think about is, a lot of times when there's no will, it often causes fights, arguments, sometimes lawsuits among family. So when people are grieving, there should be one more thing they have to deal with. Getting a will done is easy. You think about who do you want to get your stuff, who you don't want to get your stuff. Let's say, what age should children or grandchildren get money? Because I don't know about you guys, but if I got money when I was 20, I wouldn't have worked that summer. I would have went to Seaside and had someone buy beers for us. And so, think about who you want. Now, let's see. One of the things that many of us attorneys started to do is we try to make it easy for people. Everyone will call, I want to make an appointment and come in and set up a will. And that's how it was for 30 years. Back in 2019, it goes, well, listen, I'm going to send you a one-page form that you're going to type up. It's going to say, what's your name? Who's your spouse? Your spouse is usually executor 1. Who's executor 2? Who gets your stuff? Pretty simple, I'd say. And that makes it easier because for most people, we can prepare the will without them taking off a day of work to come in and go over stuff. Sometimes people will say, I want to come in and I really want to come in. He goes, okay, Mr. Shaw, let me ask you a question. You're married, right? Yeah. He goes, are you disowning your wife and not giving her anything? No, or everything in her house. Okay. How many kids you got, Mr. Shaw? I got 3. Okay. Are you leaving any of your kids out or everything equal? He goes, everything equal. Are they over 18? Yeah. I know what you need. I'm saving you a trip. I mean, I like meeting people and stuff, but I'm trying to make it as easy as possible. Right now, I've benefited so much by COVID. Same thing, not having to go to court, not even having to have my probate cases where I have to drive to New Brunswick and look for a parking space and then go to the metal detectors and wait. You know, now the probate cases, Judge Daly says, okay, we're going to do, and he doesn't even use them. He's like using a telephone. That's the best way. You know, I remember my wife and I were driving to, you know, see our son in Myrtle Beach, and I go, oh, I got court. Oh, well, you know, you have to get your allowed to know. I'm gonna talk to this new thing. I'm gonna talk to Judge Daly on the phone. It makes it easier. So, yeah. What's some of the things that you're gonna type up? I mentioned your name. Are you married? Who's executor one? Who's executor two? It's best to have not to have joint executors, because if it's joint executors, sometimes it creates twice as much work. Even they could be twins living together, but that means that two people have to sign every check. They got to go to the service office. They got to go to the closet, do everything. And that's where people agree. I've had states where it's two brothers and they couldn't agree upon what color the sky was. Brother number one, sky's blue. The other one goes, no, it's great, you're stupid, you've always been stupid. The judge started as a thing. Fellas, why don't you guys go out and have a cup of coffee or beer later and talk about the fun things you did when you were kids. So, executor one and executor number two. You know, some of our seniors say, I'm not really good with computers. Okay, fine, listen, I don't care who types it up, you know, as long as that one page is typed. And, you know, because the problem was I couldn't read people's handwriting. And of course, I'm an Edison, so I couldn't even understand how to spell the people's last names. So if it's typed, sometimes, you know, sometimes our clients, they type their own family names wrong. You know, oh, there's a typo in this. I goes, no, you typed it wrong. It wasn't me. So, you know, there's, no. If someone types it up to the family member, we still do need to speak to them to make sure it's what they want. And, you know, I always do everything 100% right. If I can't speak to them, hey, I ain't gonna do it. One time a fellow goes, oh, my dad also needs a will. Oh, but he doesn't speak English, he speaks Gujarati. Okay, listen, we can help him out probably, he knows some English, yeah. Okay, how many kids are there? 3. Okay, is everything equal? No, he wants everything to go to me. Well, then I'm not gonna do it. Number one, that smells. Number two, I'm not going to be involved with the family fight down the road. I plan on practicing 24 more years, but being in the midst of like, you know, probate fights is not part of what my plans are. You know, anything that smells a little in the beginning doesn't smell better later on, just because you put it in the freezer. All right, so we don't ask questions on assets in the will anymore because, except again for you people that have more than $13 million, it don't matter. The assets are not listed in the will. Usually it goes, okay, it's going to whomever. See? Yeah. There. Sometimes though, you know, so you're listening. Who gets your stuff? And now always needs clauses to say if that person doesn't get, who would get that person's share? Not that complicated. And some people have what's called specific bequests. What's a specific bequest? Well, some people say this. Sometimes the ladies say, I have jewelry I wanted to go to my daughter, my granddaughter, my niece, whatever. And it goes, okay, we put that in the will. Sometimes the men go, listen, you know, I'm a sportsman, I got my hunting stuff, I wanted to go to another guy that has, you know, someone in the family that has that. But I sometimes when people have specific bequests on jewelry, I'll even say, hey, have you worn this stuff in the past 5 years? Yes or no? And usually the answer is no. It's in a box or it's in a safe. I goes, okay, do you plan on using it, wearing it in the next 5 years? Yes or no? No. Then why don't you give it to them now so that they can enjoy it and it'll make you feel good. And this way, hey, they'll be much nicer to you now because when you see them on, you know, Mother's Day or Christmas or any kind of holiday, they goes, hey, listen, I'm wearing your whatever. I mean, again, it's your call. Some people also have specific bequests on to charities, churches, etc. Now, I support giving, but it is better to give a charity a specific amount than to say, oh, and I leave 1% to St. Mary's, or I leave like 2% to this, because whenever there's a bequest to a charity, the Attorney General's office has to be notified by law, and then under the law, they have to approve the accounting, and we're in the states where the accountant charges 10 grand, and that's more than what the charity was getting. But the Attorney General, you gotta do the accounting. I thought it's foolish, but again, it's like arguing with the telephone pole. You know you're so right, but the telephone pole doesn't bend and has its own things. So again, your will takes care of what your assets are. And it's your right to do with your assets what you want. Some people don't leave everything to their kids; they leave it to their grandkids. For college, education, etc. Because they sometimes say, "Hey, my own kids are already grown, have a house, but they haven't really put away much money for their own grandkids, and I'd rather invest in my grandkids' education than have if my kids got it, they'll buy a boat or a big pickup truck or something and not put the money away for college. You don't realize how much college costs until your kid starts applying for schools and goes, wow, that's a lot. Sometimes some people say, I want to leave more to this one child. I love my children equally, but this one needs it more than the other ones. Daughter number one's married to Dr. Rosenberg, the plastic surgeon, and their second house in LBI is worth $5 million. Daughter number three married the bum. He never paid alimony, didn't pay his child support. She needs it more than if my older daughter gets it, she'll buy a $100,000 piece of jewelry. The other one needs it more. So it's your call. Interestingly, last year, a client says, again, do I have to treat all my children equally? He goes, nah, you can leave everything to the Old Dog Society. What's your concern? He goes, well, one of my oldest son, we don't hear much from him. He lives on the West Coast. Okay, well, I'll ask you a question. Did you get a card or a call from him on Mother's Day, Christmas, or your birthday? She goes, no. I go, why would you leave anything to this bum? Because he's a bum. And by the way, that bum is going to be the first person banging the day after you die. Where's my money? Where's my money? Don't come out to New Jersey for the service, but I haven't got my money yet. So that we kind of called out the reverse specific bequest. You're not putting down a reason. You don't leave them $1. Nothing to X. No reason why, because they know the reason why. I'd say, I did a fellow, one of my elk brethren, says, Kenny, I want to update my will. I was leaving everything to my grandchildren, but they're in their 20s. They live the next town over. I haven't seen them in 2 years. Heard from them in 2 years. Okay, fine. Let's see. And when he passed, those grandkids' mom, his daughter, that was written out, was saying, oh, I wish someone would have told me that my dad was sick. And I really wanted to say, maybe you should have called him once a week to see how he was doing, or if he was still alive, etc. Sometimes we got, we have, people have beefs in the family. Now, we periodically get a call from someone that wants to challenge a will because they didn't get what their fair share. And I goes, okay, listen, it's going to cost you a big chunk of money, number one. Number two, the new probate judge is going to ask you the question. Okay, how many times did you visit Dad in the past 3 years? We had fallen out. Okay. How many times have you called Dad in the past 3 years? None. Okay, how about a card or a letter or an email? No, he goes, where are you going with that? You know, because I represented the estate where I remember having this lady on the witness stand and just, you know, goes, okay, and this year, tell me the date you visited your mom who lived like in New Jersey. None. Okay, tell me how many cards you sent her this year. None. And then how about this year? How about this? And then the judge finally goes, Mr. Vercammen, I kind of understand your point here. So, all right. Now also though, we usually have clauses in wills that protect children or grandchildren from their friends and from blowing the money. Because the legal age is 18, but hey, you don't want 19, 20-year-olds to get money. You know, they'll go to Seaside and have a party, and so, you know, now many people would, sometimes though, it's an adult, but we don't want to leave money to a grown person because they would blow the money. They could have alcohol problems, substance abuse problems, or whatever mental issues. So instead, some people set up similar to what's for minor children, a testamentary trust, saying the money is going to them, but it's being held by another family member, and a trust can be used to pay for their, what's needed, but in their discretion. We handled a probate case where the mom had set up a testamentary trust in the will, and the one son that had the alcohol problems, because his money is held by the older sister, and the older sister would use it to pay his rent, his car insurance, you know, other expenses, set up like automatic pay on the expenses, and then would buy ShopRite gift cards so he could only buy food, not booze. So in comes this guy, the guy's ex-wife, in court saying, Judge, I want you to, he owes me alimony. I want you to compel him to pay the alimony. That's the judge. You know, I represent the estate. He goes, Judge, the law is the law. The reason why you set up these testamentary trusts is it protects it from all debts, including even taxes and Medicaid. So sometimes we do it in second marriage situations, you know, where instead of it going all to the new, spouse number 2, and hoping that they do the right thing down the road, but never sue. I'll say that. So that's, so again, we got the reverse specific bequest, nothing to this person, sometimes a testamentary trust. Now, you could have the best will that was ever done, and it's all nice and signed by appropriately, but some of the assets, many of your assets you own, pass out automatically outside the will. So examples are, if someone owns a house, husband or wife, automatically goes to the survivor. Will can't change that. If someone has, on bank accounts or investment accounts, joint tenancy or payable upon death, etc., automatically goes to that person. The will cannot change that. Some people sometimes will put one of their kids down on these accounts as joint for convenience so they can pay bills, etc. I go, that's fine if it's the small chunk, but if they do it on all of it, I say, listen, do you understand that child gets all that money and the others don't get any of it? Well, he goes, client goes, well, I'm sure my daughter did the right thing. He goes, well, I'm sure also now while you're around, I mean, on Christmas morning, she didn't say, by the way, when you go, I ain't giving any of that to my brother. So that's all I'm like. We're going to Hawaii. And a lot of times, your own family people are influenced by who? They're influenced by whoever they're married to or living with. I was involved with an estate where Mr. G keeps calling us up. When are we getting our money? When are we getting our money? Finally, I say, hey, number one, Mr. G, your wife's a beneficiary, not you. You ain't getting any money. Let's see. And number two, you understand that each time you call saying, when are we getting our money? my office is going to charge you and give you the same answer. The answer is, we ain't getting anything. It goes to your wife, and the process got to follow the process. So it is. We do recommend that if you want for your investment accounts, if there's beneficiaries, which is good. It doesn't dispense with your having a will, but just print out the first page, and then you fold it up and you put it where your will is, so it helps the executor know, where stuff is. Now, I've done lectures with the county surrogate, and one of the things the surrogate has said is, have it done right, don't cheap out. The problems they see all the time is when people use these cheap things online, where someone says it's valid everywhere, and it's not signed right or done right, and they goes, oh, well, we can't admit it to probate. You have to go in front of spend $1,000, file a complaint order, show cause, go in front of a superior court judge. And so goes, and the person says, oh, but the company on their website says it's valid. He goes, well, you can bring a suit against them and get your $15 back, or whatever it was. So sometimes that doesn't work. Yeah. If you already have a will done, only the original will can be admitted to probate. Take it out and make sure it still has what you want. Also make sure it's what's called a self-proving will. The old way of doing stuff, 2 witnesses sign, and the person signs and 2 witnesses. But then you have to locate one of the 2 witnesses. And then you had to pay them and have them sign a affidavit or go to the surrogate saying a self-proving will under the new law. The person signs, 2 witnesses, the attorney and notary, then the 2 witnesses, a person signs again, 2 witnesses. So that way the witnesses don't have to be located. All the surrogate needs is the original will, death certificate, check for about $190, and they give you your letters testamentary. If you don't have a will done and you own something, get a will done. Whether or not you call attorneys, they'll get it done and they'll get it done right. See, the surrogate also, like when you're doing the seminar, goes, the problem sometimes with people doing this stuff themselves is they don't do it right, and they didn't really save money. My first house was this wooden Cape Cod in Edison, and I remember you all had landlines and had you had the line. I was so proud that I was able to run other lines into the other rooms, and I'm smart. But it was also all electrical, so it was at 2-prong. I goes, oh, I got to take the 2 prongs into the regular 3 prongs, and I can do this. I'm smart, and I almost burned the house down. So. I don't do any electrical work anymore, by the way. I hire people to do it. Okay. Don't be a Carl. Carl was this retired engineer, and Carl, came to see us because it was when the estate tax was still around. And he goes, listen, we can separate it between you and your wife, so there's no estate tax at all. And it'll save you 30, 40 grand in federal estate taxes. Well, I want to read more up on this. Carl, you don't need to read anything. Look, I went to law school, I passed the bar, I go to seminars, I wrote a book on this stuff for the American Bar Association, so they must think I know something about this. Well, I want to read more up. Okay, fine. 2 years later, Carl's daughter calls us. Do we have his will? Carl died. No, he wanted to read more up on it. These engineer types that, they would get a new car and they would want to read the book from cover, the whole thing from cover to cover. They would want a lesson on how to use, back then. I need a lesson on how to use the jack. Let's see. I know how to use the jack of my car. I call AAA, I call Ford Motor Credit, and I also call the insurance company. I see which one of the companies which one of the trucks wins by getting there first. I'm not going to get hurt changing the tire. Okay, so, and by the way, some people that work for big companies, they have legal plans, which we participate in. One's MetLife, one's ARAG, one's Legalese, where as part of the person's benefit, it pays for their will. You know, so, you know, interesting. The people that have special needs kids are smart to know they need to set stuff up. But other people goes, oh yeah, you know, I'll get around to it, I'll get around to it. Listen, if you don't have your stuff, do it now. We get a call once a week. Oh, I need to get power of attorney over mom, dad, my brother. I goes, you can't get power of attorney over anyone. They need to affirmatively give it to you. They got, you know, they got to tell us what they want, and they got to sign something. And if they can't do that, you can't do the power of attorney, and you got to go through a very expensive guardianship procedure. Having wills done is not that expensive for what you're getting out of it. You know, the cost of a will varies between, you know, $500, $700 each. But if there's no will, the cost is substantially more to go through administration. So, yeah, you're saving the money if you don't do it, but you're kind of making, oh, I'm just punting it and like my kids got to do that. You know, so, oh, and if anyone comes, whenever people come to our seminars, typically all attorneys charge a consult fee. We don't charge a consult fee if someone that comes to our seminars, if they, we will email them the questionnaire, they type it up and send it back. I'm going to be remote a lot of the next couple of weeks because my wife, after she retired, she goes, okay, we got to now start traveling. Because, you know, my wife goes, we only got like really 10 more good years to run up and down mountains and, you know, hike Mount Everest. I shouldn't say that. We're not hiking Mount Everest. All right, now.
I have a question.
Yes, ma'am.
So you said New Jersey no longer has an inheritance tax.
Yeah.
What about federal?
Well, federal's at $13 million. So since you have more than $13 million, it applies to you. Now, okay, well, I didn't say, they got rid of the estate tax. There is an inheritance tax. There's no inheritance tax. It is going to spouse, children, grandchildren, or charities. If it's going to brothers or sisters, the first $25,000 is tax-free. After that, it's taxed 11%. Every other human, there is a tax of 15%. We're helping out with an estate where the one fellow goes, oh, it's a shame that we got to pay. You know, I got to pay like 15% tax. So he goes, well, do you want to not get the money and let the other people have it? And I'll take the money. So there is, so if it's going to those people, no inheritance tax. The estate tax though is now is $13 million.
And I have another quick question.
I'm ready. Tell me any questions you
I'm
got.
going through this right now with my mom and we'll take care of everything. So, like my name is on all of her bank accounts and her investments and retirement, whatever. So, does that stay in there under my name, or then is everything sold and I get cash?
If you're the direct benefit, I was with a couple today, and dad passes, and under the will, he gets half, and his dad's grandchildren get the other half. He goes, but dad also had, you know, the investments, the bank account. He goes, my name's on it. He goes, that's all yours. Give them the death certificate. They'll send you some forms, and that's your money. He goes, it doesn't have to go through probate. No, that's your money. You know,
my name's on.
You know,
okay. Now what about the ones that my name's not on because like her retirement or her retirement?
She should put on everything. How many children are there?
There's two.
There's two. So the question is, if she wants it all to go to one, right away run off and do that. You know, put on who they want. And by the way, while we're talking about that, it's also important when there's minor children to not put them down as beneficiaries on those accounts, because the will can't change who's the beneficiary. So if someone has minor children, they get the money when they turn 18. And they go over to Maloof and they say, you got any sports cars? You know, because their friends go, this is your only chance to buy a sports car. So if that's what the person wants, they should do it. But it shouldn't be done through a power of attorney, because the other person will say, that smells undue influence, You know, it should be, you know, the person's account is, go to the bank person, if they can't drive, the other person waits outside. This way, the person at the bank can, you know, have them sign the papers there. Did that answer that question?
Yes.
Okay, good. All right.
I have.
Yes, ma'am.
It's sort of related
Yeah.
to her because I'm not quite
Yeah.
sure. You mentioned about the inheritance tax, or if you only have like one child and their income is below 13 million, did you say?
Yeah.
For capital gains.
Yeah.
It
There's
has to
no
be-
capital gains.
There's no capital.
See, under federal law, let's say you bought a house for $100,000, okay? And now it's worth $450,000. If you pass away, there's what's called a step-up in basis, so the beneficiaries on passing don't have to pay any capital gains.
Okay.
But if someone says, oh, I want to put the house in my child's name, who doesn't live with me, it goes, okay, well, they get your original basis of $100,000. When they sell it for $450,000, they're going to pay capital gains on the profit, on the difference. Is that what you want? No. Okay, I didn't think so. Well, someone said, it goes, was that person a lawyer or someone that you were talking to, or your own child? You know, a lot of times it's the children that want to do. Oh, mom, dad wants to do, you know, estate plan. Oh, their kid wants to do inheritance protection, protect their inheritance. Okay.
I have one more question.
Yes.
It's sort of related. I'm not sure, I forget what you call it, but you can put your house in your child's name, but you still pay the taxes. And it's, say, if I went into a nursing home.
It's a 5-year look back.
Yeah, it's a
5-year look back.
5 years. You have to be in there for 5 years. But that would have nothing to do with him with capital gains, because my estate's not worth more than a 13 million.
No, if it's in your daughter's name, she gets the original basis. So it doesn't matter who pays it. When she sells it, she's paying the capital gain.
So are you a proponent of doing that?
I do. It's whatever people want. And I'm going to touch upon in a couple minutes on Medicaid and nursing home related stuff.
Okay.
Okay. Yes,
I have a
ma'am.
quick question.
I'm ready.
You were saying about brothers, the 25,000 tax-free, passing
Yeah.
tax-free. Does that apply to nieces, nephews,
No,
all of those?
they pay 15%.
Okay, great.
They pay 50. Any other questions on the will portion? Okay. My mother-in-law is still around. She's 93. She used to call me every other year. She's, I want to come in and get a trust. I would say, were you watching Susie Orman on TV? She says, oh yes. I go, Susie Orman is right. If you live in New York, California, Florida, where probate takes 3 years, costs minimum $15,000 on the singles. I goes, but New Jersey, probate is easy. There's no reason why people really need to set up revocable trust to quote avoid probate, because probate's easy and it doesn't protect assets from anything. It doesn't reduce taxes. You know, some of the trust salesman goes, oh, it gives you privacy. No one knows, but a will is a public record. He goes, well, yeah, unless you're giving your money to like the Ku Klux Klan or something like that. What do you care if people know who's getting your stuff? You know, don't matter. So so there's no real need to avoid probate in New Jersey. If people have real estate in other states, sometimes they will set up a revocable trust. It's not just setting up a trust; it's having to do new deeds and having that asset owned by that trust. That's a revocable trust. Yes, ma'am.
But now this ties into my question, what she just said, because I was told to start looking into, my sister's pushing me to do this, to put all my mom's stuff in a trust, so if she has
Okay,
to go
so
into a nursing home,
there's a
they
different one.
will
That's
back.
called an irrevocable nursing home trust.
Oh,
The attorneys that do it are going to charge between $12,000 and $15,000. Okay, that's what because that's the cost of a nursing home for a month. Okay, so when the kids say this is what mom should do or dad should do, okay, good. Take out your checkbook and write a check. Oh, I don't want to spend my money. Now, I mentioned something about, children are concerned about inheritance protection. And so lady comes in with mom and says to me, what would I do, or, on that. It goes, this. If I am that sick and ill that I can't get up and, do my stuff and wash myself, I don't care how much it costs. I want to go into the most expensive nursing home that exists because I'm the one that worked for that money. Let's see, there's nice nursing homes and there's dirty, disgusting ones. I want to go into the nice one. Let's see, yeah. Do you remember in the olden days before cell phones, and how did we ever get to places without having GPSs, etc.? And how we even were able to do anything. So I do a lot of these running races, and my grandma lived to almost 105, and there was she was at Fountain View, nice place on Route 9, and down the road, that was in Lakewood. And nearby, there was the 10-mile running race that my one club put on. So I go, hey, listen, one of my buddies is giving me a ride to the race, and they're going to give me a ride over to the nursing home. Why do you come down with the grandkids? It might be the last time they see their grandmother while she can have a conversation. Okay. So, you have it written on a piece of paper, Fountain View, nursing home address, Route 9, and you're looking at the Hagstrom map or whatever, driving down Route 9, and then sees nursing home, pulls in, goes to the front desk, the kids are there, and she goes, oh, this place smells so bad. Ew, it smells bad, it's dirty and disgusting. Oh, that's I'm only supposed to go 35 minutes. But she goes, and so she goes and says, I'm here to see Virginia Vercammen. So, no, not here. Oh my God, I lost Ken's grandmother. He goes, no, I'm supposed to meet my husband here, 415 Route 9, Fountain View. He goes, oh no, this is Smelly View. Fountain View's down the road. So, I worked as a newspaper boy, and everyone, when they were younger, worked hard. Why should I, or any of us, have to go into the smelly nursing home so that my son, Dr. Brendan, can have a bigger fishing boat to go with more electronic gadgets? Let him work. But I said, that's me. If someone says this is what I want to do, it's going to cost you money, but at least that's me. Because frankly, I don't trust my kids to spend the money to put me into the nice one. That's mine. But anything left over, that's mine. Okay. Next, let's talk about the power of attorney. The power of attorney. The will takes care of your assets if you pass away. And what the power of attorney is, while you're alive, you're giving the power to someone to be able to act on your behalf. You're not giving up your rights, but you're giving the power to someone to do so. All right? The power of attorney is either effective right away or only upon disability. I recommend it be effective right away. That's called the durable power of attorney. It stays in effect if someone becomes disabled. There's a different power of attorney only comes into effect if someone becomes disabled. That's called the springing power of attorney. Last year, our client Freddie goes, Caddy, I'm a carpenter. I don't understand legal stuff. Explain to me in carpenter language. Okay, Freddie, listen. You have your son as your executive, who's also your agent on your power of attorney. If it's effective right away, you can steal all your money right away. If it's effective only upon disability, he has to get a note from a doctor before he steals all your money. Do you trust your son? Yeah, I trust my son with my life. Good, make it effective right away. Now, a will is good forever. It never expires. It doesn't when you get invalidated, you move to another state. Sometimes you might want to make changes if the executive can no longer do the job or if it's not where you want your stuff to go. A power of attorney, though, there's no statute that says how long it is good for. And most institutions outside New Jersey, won't recognize it. So, I recommend that we typically recommend our clients re-sign their power of attorney every 5 years, even if there's no change. Sometimes we look to see, okay, at least sometimes we do a new one because someone, I'm talking to a guy today. Don, you need a new will and a new power of attorney. Okay, what? Okay, where's the original one? In the house somewhere. Do you know where? No. Do you remember how many years ago it was? No. You have no idea where it is, right? Somewhere in the house. So he goes, but when you did it, your wife is was the executor, right? Yes. Okay. She don't drive and she'll leave the house, right? Correct. Okay. You don't drive, you don't leave the house much, right? You're going to be 91 years old tomorrow, right? Yes. And your daughter does all your stuff for you, right? Yeah, your daughter lives in Jersey, yes. Then have your daughter be it, not the other person. Because I mentioned we get a call once a week. I need to get power of attorney over X. Can't do. And a lot of times it's too late. I lived in Edison for a lot of years. One of my neighbors says, I want to move. Well, the word was, we're moving to Carolina. We got a closing date next month. I need a power of attorney so I can sign for my husband at the closing. Okay, when can your husband come in to sign? Well, he can't, he had a stroke. Okay, well, where's he at? Roosevelt Care Center. Can he talk and is he competent? No, not really. Well, you can't do a power of attorney. He goes, well, how can we sell the house? He goes, well, unfortunately, you can't. You'd have to go through this expensive and complicated guardianship procedure. He wants it. That's why you should have had the power, had a power of attorney. Now, one of the things, like I mentioned, Circuit also says about using cheap stuff online. Some of the institutions weren't honoring a perfectly good power of attorney. So, the New Jersey legislature came up with a law that says, hey, if it makes reference to the New Jersey statute, they're supposed to honor it. But it had to make reference to Section 2 of PL 1991, C95, 2B-11, and the cheap things online don't say it. So, if you don't have a power of attorney, get one done. We do a ton of powers of attorney every August, where people's 18-year-old, 19-year-old kids are going off to school, and they realize they don't have any way to talk to school or anyone without having.
So you have to have a will and a power of
Yeah, so there's three main documents most people have. Number one, a will, last will and testament. Number two, a power of attorney. Number three, a living will. Now, what the living will is, that's the document where you're saying, listen, I don't want to be on feeding tubes, respirators, etc. If it's kind of the end of life thing. You can know, as long as you can talk, you're the captain of the ship. But it's usually where you can't talk, etc. And if the document's not really for you, it's for your family, so they don't have to be put through the trauma. Because I remember one time the doctor asked me the question, "What should we remove life support today?" And he goes, and the person did not have a living will. I was the power of attorney. He goes, "Geez, I feel bad. The right call is for someone that is 92 years old that's not going to, open up their eyes again or enjoy life and is suffering. But, you hate to be the one, oh, yeah, go ahead and do it. I mean, it's tough doing it, doing it for your pets, let alone you. So, you want to have a living will advance directive. Okay. I went past my time, but let me tell you, let me have 30 more seconds before I bring up Dean Fabrizio to talk about probate. Probate, if there's a will, probate's relatively easy. Okay? They need the original will, does give a check for $190, and then most people say, in some states, some people say, Kenny, I want you to do most of it because I don't want to have to learn a new skill. Notice of probate gets sent to all the everyone who's listed in the will, plus anyone who would have inherited if there wasn't the will. Even though there's no inheritance tax, when there's a house, we file an inheritance tax return so we get tax waivers so the house can be properly sold. The executor will obtain a tax ID number, set up a state account, and then just use that as like, and then the best thing executors should do is, I tell everyone, every 3 weeks, email everyone, BCC, but email, this is what's going on. Sometimes we're waiting for a seller in the house, or we're waiting for a response from Trenton on the inheritance tax return. This way, no one says, I haven't heard from my, my brother in 8 months. I don't know if he's like sold the house and took the money and went to Cuba with it. At the end, typically the executive will do an informal accounting. Usually it's just, hey, here's the Excel sheet, here's the bank ledger. We did the math, you're getting X amount. The attorney has prepared this document called the release and refunding bond. If everyone signs it, then you don't have to go see the judge and go through a formal accounting. If someone's a pain in the ass and says, I ain't gonna sign it, okay, then you gotta go through the formal accounting and in front of a judge. But then we send letters out to everyone else saying, sorry, nobody gets your money now, because brother or cousin Steve won't sign. But if Steve does sign, then everyone gets their money and the estate won't be depleted by $10,000 in extra costs. And by the way, this is Steve's phone number, email, and address, so you go bang on his door and it makes sense. So with that, my name is Ken Vercammen. My phone number is 732-572-0500, but that's on the pamphlets. Now, sometimes people will say, I want to talk to you about like some financial advice. I didn't do my own taxes. I haven't done my own taxes since my wife and I were first married 35 years, and before computers and didn't do it right. So Dan's going to talk to you for a little while and answer some of my financial advising questions. Thank you.
Can I ask a question?
After he speaks, I'll see you in the back, okay?
Thank you, Ken. Good evening. My name is Dan Fabrizio, financial advisor with Life Securities, a New York life insurance company. 22 years I worked on Wall Street as an equity guy. We're institutional investors.